and it's around evictions. The question goes, an eviction was granted against me in court. I have never had sight of the Section 4.2 or eviction application. Can I bring a rescission on the basis of being unaware of the applications in the very first instance? Bruno, what advice can we give our viewers on this?
So let me answer this in the most objective sense, because I think it's an important question that can be addressed from both the landlord's perspective and the tenant's perspective. So it's not to necessarily advise the tenant, yes, you can do this, or no, you can't. But I think the approach to the evictions actually needs to be pivotal here, and it's crucial to this question. So the whole point, like of court proceedings in general, is you're trying to give the other person some form of notice that you intend doing something, that there's a process against them, that they have the right to defend, etc., etc. So in principle, if you serve, whether it's a summons or an application or whatever the case may be, the whole idea is to try get this person and give this person notice. Yes, there are certain exceptions in our rules that allow for service of documents in another way, especially if you can't find people, or you apply for substituted service. It's a whole complex process, but typically when it comes to evictions, that is not the case. And the reason for this is if you're applying for someone to be evicted, you're almost guaranteed that you know where the person is, because that's exactly where you're going to serve the papers. And it's not like a summons and money where you need to go trace the person somewhere in South Africa to try get money from them. So you have a property and you have the person living on the property. So that already kind of deals with how you should serve this notice. And what you typically find is the courts have the expectation that this process is followed. The courts will want the document, the main application served on the tenant or the occupier, will want the Section 4.2, and in most instances, in my experience, the judges and the magistrates will want to see personal service. So the first thing that I need to point out is it's very, very unusual that an eviction order would be granted where an occupier would have absolutely no notice at all, because the return of service would normally indicate that it was given to someone on the premises. So the only time something like this may happen is if there's some form of justification where the court has found that access to the premises is extremely difficult, everyone's tried their best, and they've attached it to the front gate. But then it's attached to the front gate. Right. Other instances I found where people were trying to hide the notice. So it was served on someone in the premises, and instead of handing it over to the occupier, they threw it away or they did something of the sort. Right. That has happened. It's very unusual, but the situation has arisen. And the third circumstance is, for example, if a sheriff were to lie, but as an officer of the court, that one doesn't expect something like that to happen. So simply on the possible scenarios that could have led an eviction order to be granted without somebody knowing about it, there's a lot of questions that we need to ask. And I'd love to know what the return of service says and why a magistrate or a judge would have granted the order in the first place. But hypothetically speaking, if we're looking at a situation where the magistrate accepted a service simply by affixing without asking any further questions, and the person genuinely did not know, everyone's entitled to apply for rescission of judgment. But remember, rescission of judgment is typically done on two legs. The one leg is, did you have notice? And the other, the one leg is, did you have notice? The second leg is, do you actually have a valid bona fide defense? If this thing were to actually be heard, is there a chance that you'd even succeed? And the court looks at these two legs and balances them out between each other. Because the reality is, if you knew about it and have a defense, if you knew about it, but you didn't do anything and you left it, a court will look and go, well, you know what? It doesn't matter whether you have a defense or not. You left it, and you prejudiced the other side. You should have done something when you had the chance. So in a case like this, if the person genuinely didn't know, and it shows that the applicant like lied about them receiving notice, there's a chance for a rescission. But typically speaking, the court will still ask, okay, but let us know, what would you tell us if you did defend? What would your defense be? And if the person doesn't actually raise a defense that has any opportunity of standing up before a court, you will likely find that a rescission won't be granted.
Thank you so much, Bruno.